Pasha Paro. Thank you for tuning. It's gonna be a YNet 7 moment. So appreciate all y'all. If you're watching on the music side, I'm kind of giving you a glimpse. I'm kind of merging the two. I I had the YNet 7 channel where we talked about a lot of these breakdowns, and I'm just gonna start including you guys into those discussions as well, because it'll be best for you to really understand the music, so to speak, and what the messages are in the music and the songs. If you understood, some of this, the backstories behind it, and got to know me a little better and what we stand for as Americans, in comparison to some United States shit. So what we're gonna go over today is gonna be back to the Civil Resource Manual book. You can see this online. I just actually have a physical copy. We're gonna pull some information from Black's Law Dictionary, 1933 edition. And if you haven't already got this book, be sure to pick that up. It's a great book. Well, what I want to talk about today is gonna be venue. Okay. So venue is number 38. All right. And in that, you get it states here that the general venue provision is found at 28 USC subsection 1391. Okay. Venue is primary. Matter of fact, let's just pull that up. Let's just go look at that real quick. We'll come back to that in a moment. So here is the breakdown for venue, and it states here's 28 USC subsection 1391 venue generally. All right, so applicability of section says, except otherwise provided by law, this section will govern the venue of all civil actions brought in district courts of the United States, and the proper venue for a civil action shall be determined without regard to whether the action is local or transitory in nature. And transitory is like temporary. So I guess it's saying, regardless if they're permanently there or temporarily, right? So venue in general is a civil action may be brought in a judicial district in which any defendant resides if all defendants are residents of the state in which the district is located. Okay. A judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of a property that is the subject of the action is situated. Or 3, if there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. So what we're going to do is we're going to go over this, right? I want to share with you what the venue is in Black's Law Dictionary. I'm going to cover a great opportunity for you to comprehend how this works in your favor, or what you need to be aware of if you're a business owner or just dealing with your own personal matters. And I'm even going to give you some insight as to how this may help you in your personal relationships, like those type of, just to comprehend it better, and you may apply it. And we're even going to talk briefly about how this, give you a clearer picture of the term revenue when it comes to that paper shuffling all around the place. All right. So, and then at the end of that, we'll look at Leroy versus Great Western Corp from 1979. I got the oral arguments, and we'll get to observe that and listen to the actual court case presentments from both sides, and Then they'll close out with their justice opinions. Okay, so let's get back to this real quick. So it goes into residency for all venue purposes. A natural person, including an alien lawfully admitted or permanent resident in the United States, shall be deemed to reside in the judicial district in which that person is domiciled. Two, an entity with the capacity to sue and be sued in its common name under applicable law, whether or not incorporated, shall be deemed to reside if a defendant in any judicial district in which such defendant is subject to the court's personal jurisdiction with respect to the civil action in question, and if plaintiff, only the judicial district in which it remains its principal place of business. So if you're the plaintiff and you bring the case, that's what they're saying. You want to stay and look at there. This is all entertainment purposes. I'm not an attorney. I'm not a lawyer. I'm just an American, and diving into knowledge of this is part of what kind of helps you know that you're American, like versus being a United States citizen. Like you need to start to build your knowledge of this so that you can be, I ain't gonna say independent, but non-dependent on certain resources so that you can be part of the majority by definition, not the minority by definition, which means to be like child. Okay. All right. So number 3, a defendant not resident in the United States may be sued in any judicial district, and the joinder of such a defendant shall be disregarded in determining where the action may be brought with respect to other defendants. So a defendant not resident in the United States may be sued in any judicial district, and the joinder of such a defendant shall be disregarded in determining where the action may be brought with respect to other defendants. So keep in mind about this residency situation. It's kind of like your relationship, and I'm gonna get to that in a moment. Let's say a long distance relationship. I'll give you that example. I got some notes here for you, but I want to cover this real quick. There are reasons why you may decide to change the venue of certain things, and we'll get to that in a moment. So residency of corporations in the United States with multiple districts. So here's where it starts to get interesting. For purposes of venue under this chapter, in a state which has more than one judicial district and in which a defendant that is a corporation is subject to personal jurisdiction at the time an action is commenced, such corporation shall be deemed to reside in any district in that state within which its contacts would be sufficient to subject it to personal jurisdiction if that district were a separate state, and if there is no district, the corporation shall be deemed to reside in the district within which it has the most significant contacts. So now, let me get big on the screen for you. So now this is the default settings. Like, you know, when you start your video game up and it gives you the basic startup, you can go in and modify shit. So remember, this is saying this is what is going to be the standard if there are no other applicable motions to it, right? So, you know, that law of inertia, an object will remain at rest unless acted on by outside force, right? So unless there's an outside force in addition, some additional force outside of the basic, this is going to be the, hey, if anything happens, you agree to that if you decide to take us to court, you agree to have it in this state. It's going to be in this state. So you already, no matter if you're 3,000 miles away, once you contract with that agreement and move forward, you've already agreed to those terms. So you would have to have something in addition to that to supersede that agreement within the four corners rules. Okay, so keep that in mind also when you're exploring this in your mind hereafter. All right, so we already did this. Yeah. So actions where a defendant is officer or employee of the United States. So in general, a civil action in which a defendant is an officer or employee of the United States or any agency thereof acting in his official capacity or under color of legal authority, or an agency of the United States or the United States may, except as otherwise provided by law, be brought in any judicial district in which the defendant in the action resides, right? B, a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of property that is the subject of the action is situated. So keep in mind, property is also a factor here. So far, it kind of sounds like what you've heard above. So, or C, the plaintiff resides if no real property is involved in the action. Additional persons may be joined as parties to any such action in accordance with the federal rules of civil procedure, and with such other venue requirements as would be applicable if the United States or one of its officers, employees, or agencies were not a party. So then if it's a service, the summons and complaint in such an action shall be served as provided by the federal rules of civil procedure, except that the delivery of the summons and complaint to the officer or agency as required by the rules may be made by certified mail beyond the territorial limits of the district in which the action is brought. So basically, at this point now they can modify rules because the US is, nationwide, is on your side, right? So civil actions against foreign state. So a civil action against a foreign state as defined in section 1603A of this title may be brought in any judicial district in which a substantial part. So it's basically going to give you kind of the same things here for the first one. Okay. And then it's different here in number 2, in any judicial district in which the vessel or cargo of a foreign state is situated, if the claim is asserted under section 1605B. And then any judicial district in which the agency or instrumentality is licensed to do business or is doing business, if the action is brought against an agency or instrumentality of a foreign state as defined in 1603B of this title. So in the United States District Court for the District of Columbia, if the action is brought against a foreign state or political subdivision thereof, okay? And then lastly, the municipality multi-forum litigation, a civil action in which jurisdiction of the district court is based upon 1369 of this title, may be brought in any district in which any defendant resides or in which a substantial part of the accident giving rise to the action took place. Okay, so what's the interesting thing from there? I mean, get familiar with these locations, make notes, get you physical copies of what you can, even though it may be online. You don't know what the future brings and what they'll allow you to have access to in the future. So now let's go back to here. Okay, so this is basically going to give you, I like this book, the Civil Resource Manual. I've done several other videos about this. We're up to 38 now. I skipped over the effect of Declaratory Judgment Act and the Administrative Procedure Act, which was 36, and then 37 is the indispensable party. So we'll maybe look at that in the future. Maybe we'll keep moving, but stay tuned. You'll find out. So I like this, but it gives you the breakdown each section here. Now remember, I'm a fan of if you actually have anything going for anything. You're breathing. You should get this. You should get this book. You should read this on your free time. I know. I'm glad that you're here with me on YouTube and Facebook, and maybe start to give some of your time to doing this. This is why I do this. I want to introduce you to things because when people tell me I sound crazy, people, from yourself, people really enjoy hating what they do not understand, and that is the problem, because what hate is like a crossroads. It's like a fork in the road between they are afraid of not knowing the battle that's before them, like how much of a fight they're gonna have to put up. And then that's the fork in the road with not having enough knowledge of that and the subject. If they're hating on you, they don't know enough about you. They hear something they don't like. They don't know how much of energy or effort they're gonna have to put in. It's the way your brain is programmed. So it's easier to hate, because then from a distance they can feel like they're fighting a battle that in their mind they're winning, because how do you defeat hate? You know what I mean? Like, so they're gonna be like, yeah, we're winning. We hate them, and that's what it's all about. So basically, a lot of the hate, or a lot of the things that people hate on, is simply because they don't know any better. They don't have enough information. And then it's easier because you rather click the like button, right, than to sit down and do some research. So until we as a community get to the point where we start to put the energy in, the effort into things aside from SneakerCon and the other stuff, then we're always going to be, the community as a whole will be dependent upon beliefs without no knowledge of, and then that's dangerous. Okay, so let's move on here. Let me get this back up here for you, and we can go to, all right, so let's look at what venue is in the Black's Law Dictionary, and I'll read it to you from here. So it starts off with saying, it's kind of cool how it was originally spelled VISNE, like, but anyway, in pleading and practice, it says it's a neighborhood, right? The neighborhood, place, or county in which an injury is declared to have been done or fact declared to have happened. Okay. Now, of course, there's some additional meanings and uses here. So also the county or geographical division in which an action or prosecution is brought for trial, and which is to furnish the panel of, and then it goes to the top. So let me get you the next top page. Here you go. To change the venue is to transfer the cause for trial to another county or district. All right. And that's kind of like what I want to focus on for you guys today, so that we can build our knowledge together, and where this applies, you can be stronger in your own applications in life, which makes us more powerful as America. Okay. All right. So, and then it gives you some court case citations to review. That's why I like this, because you can go review the cases and actually get understanding. Again, we're going to, at the end of this, check out Leroy versus Great Western. So we're almost through this part. I'm gonna go into this one other example I want to give you from the Tools of Argument book for lawyers, and show you how what this actually means in layman's terms, very simply with a diagram. And then we'll spend the argument for the court cases about an hour and a half. So once we get to that point, um, it'll be about another hour and a half where we actually get to listen to the court case and see the battle go unfold in front of us. But before we get there, I'm going to break down how this actually could apply in everyday use in like your relationship and business, so that it really makes sense on a fundamental level that is easy for everybody to get. So the last part here says, however, the transfer of a case from Division 2 of a county circuit court to Division 1 thereof may also constitute a change of venue. All right. Again, Black's Law Dictionary, 1933, third edition. Great asset to have. All right, we covered the Civil Resource Manual. Again, this is directly online. Just type in Civil Resource Manual and you can get that. What I want to go to now is this right here to show you why this makes sense. All right. So basically, what this section of the book was talking about, an example. Again, and here's the book. Pick this up if you haven't already. I've told you guys on Facebook and YouTube and all the videos. It's a great tool and really helps you prepare any cases, or really just helps you generally in conversation, because so many people, you know me, I'm equations, not variables and all that stuff. I'll be saying, but this really helps you use the tools basically that demonstrates. Look, a lot of people don't know how to argue, and this is what slows down a lot of progress. And then their emotions get involved, because then emotionally they feel like they're right. But if you knew how to control the conversation and control the focus of the conversation properly, then a lot of things wouldn't need to escalate, right? And you can sit down and make more educated decisions, cover more territory, so to speak, in the same amount of time, to get you guys to a point of understanding what needs to be done, and then you can move on from there. So very great tool to have. All right, Tools of Argument. So in this book here, because we're talking about the venue, what it was covering is that a court case was dealing with, remember where I was talking about on US or Section 28 US Code subsection 1391, where it was saying the different residing factors, like where company one was, or where the plaintiff lives. You got where the defense lived. You got where the action took place. So if you got a business, right, and your business is in North Carolina, and it's chartered in Delaware, and your customer is in Wyoming, you know what I mean? You got the opportunity, and depending on your contract structure, you have the opportunity to maybe have a case move from one area to another area of the country, or even the world in some cases, to make it more palatable or beneficial for yourself. And you want to do that, as much as possible to give yourself the most leverage in the case. So in this example, I won't go into the details given in this example, but look at the graph here. It's showing you that if this particular case, you're dealing with Japanese or Japan, like, so either the defendant or the plaintiff was in Japan, or then you got French, and then you got Kansas, the United States, right? So, or America, depending on who they think they are. So in this situation, it was showcasing you the benefits, the pros and cons of being in each situation. So if you were to fight to have this move to the Japanese court and put under French law, right? Because now venue is also not only the physical case for that benefits, but also what laws do you want to have applied to your particular case. All right. So you could take this to a judge, and that's what a lot of people don't know, is that you're, even in your quote unquote US courts, they have to practice, they have to know all the international law pretty much, because you can have an international case here and it'd be tried, so to speak, in the court right around the corner from you. Okay, so they need to know that. All right, so in this case, you could go to Japan. Not you could go, but I mean, in this situation, they had the opportunity to decide if they wanted to have this case in Japan using French law, the plaintiff would probably lose. If they went to a French court under Kansas law, the plaintiff would win. So even though they would be in France, they could bring in the Kansas law because of the venue factors, right? And the plaintiff would stand a good chance of winning. Now, they go to a Kansas court under French law, the plaintiff would lose. So under these three examples given, it would be best, obviously, for the plaintiff, if that was you, to have this held in a French court under Kansas law. So you would want to move a position, the situation, to be tried there for yourself. Okay. All right. So like, now look at it from, you're in a relationship. It's long distance, right? So what the venue is going to be is like choosing. You're in different cities, okay? You have disagreement about something important, and you want to decide, where to meet to have a conversation. Or maybe you meet this chick, or if you're a chick, you meet a dude, or whatever your thing is out there nowadays, and you live on different sides of town. So you guys, it's 2023. Now you can't know where I live, right? You don't want her to know where you live at yet. So you're like, hey, how about I pick you up? They drop the same card on you. Nah, not yet. I don't want you to know where I stay. Whatever, right? So anyway, you want to meet somewhere for some reason, right? Whether it's you want to call it a date, or in the case of maybe you need to talk about this disagreement, you're going to pick somewhere that's convenient to have this meeting or conversation, right? So especially if you're long distance. So should they meet in one person's city or another, maybe you flip-flop or find a neutral location. That's similar to choosing the right venue for the discussion. So in a legal context, because I have my notes here to make sure I don't miss a beat for you guys, because I need you guys to really get this together so that you can use this in your own conversations and thought processes every day. And then we can start to build up the people around us. And that's how we're going to restore America slowly but surely. Okay. This is one step like this at a time. Don't worry. Don't get overwhelmed. We're going to do like the CIA, and we're going to take one small task, do that first, whatever's the quickest. So the quickest is this video right now. All right. This is going to be part of us changing the world together. All right. Pasha Pabo. So now you decide where you want to have the conversation so that it's convenient for all parties involved. Or if it's a group of y'all wanting to meet up and go, wherever, you know what I mean? Maybe you're going to go on a vacation or something, camping, whatever. You're coming from all over the country or the world or the state. You're going to pick that neutral spot. Some people might have to travel further, but you all decide and be okay with it at the end. So in a legal context, venue determines where a lawsuit should be filed, often where one party resides or where the incident in question occurred. Okay. So that's the meeting on, this brings us to like the meeting on the neutral ground. So like we said, sometimes it's best to have the conversation in a neutral spot. Like you don't want to go over her place because the parents are in town and they're going to be there all week or all season or summer or something or whatever, right? And you're like, fuck, I just wanted to, whatever, right? and then she doesn't want to come over there because maybe you got, you know, your dog sitting or something. She don't like dogs, whatever the case may be. So you might have the neutral. This is where, for example, you meet the chick at the club, you go to the hotel, right? You get the neutral setting because that way nobody has to feel uncomfortable, or that you can feel more comfortable, right? It decreases the chances of you being ambushed or set up or whatever, right? Little stuff like that. Not that it eliminates it, but it just decreases. So it gives you a more comfortable setting, a more neutral setting. So in a legal case, the venue is often chosen to ensure fairness and convenience for all parties. For example, if someone involved in a car accident, the lawsuit may be filed in the county where the accident actually happened, ensuring that both parties have equal access to witnesses and evidence and all that stuff, etc. Right? So, convenience and accessibility. You see how this is a reoccurring theme here. If you're again going back to what I was mentioning, a couple planning a vacation together, you might want to choose a destination that's convenient and accessible to both of them. Or if you're in a large group, like we talked about. So in the legal case, the venue is often chosen to make it fair and convenient for all parties, including witnesses and attorneys. Again, this is what venue is to help you understand it in like an everyday example. All right. So respecting rules and agreements. So if you make an agreement about where you're going to have that certain discussion, issue, or vacation, whatever, for instance, you might agree to address in a relationship, you might say, hey, we're only going to talk about financial matters at home. Or if you have a relationship issue, you may wait to talk about that in a quiet, private place, right? So in a legal context, venue rules and agreements are important to ensure that lawsuits are handled in fair and consistent manner. Parties have to follow the established rules and agreements regarding where the case should be heard. Okay, so this is where once you decide, hey, we're going to France to have this case, you can't hold out and be like, well, I'm gonna meet you in Texas, and you got, once it's established, you gotta be there, you gotta show up. That's where it's at. That's where it's going down. And then same thing with which law you're going to use to apply there. So if you're using Kansas law in France, you're going to have to restructure your case if you prepared it for Japanese law. And this is the same thing that happens to us in conversations, because people come with their emotional attachments to beliefs, right? And that's why you hear me say, and the more we bond together, the more you pick up these habits too. We're going to be equation based, not variables. So we're going to be focused on the truth, because truth is infinite. In order to be true, you have to consider the infinity. And that's what, makes us solid, right? Omnipresence. So when they come with their emotional variables, it normally fits into the infinity of truth, unless, even if they're making it up, it's still part of infinity. Like, it's just false. You know what I'm saying? So what happens is you have to be able to help revenue their concepts or your position to align with their rule of thought to make it make sense. All right. So change of venue, as we discussed, sometimes, the couple might agree to change the location of the difficult conversation to make it more comfortable for one party, or change the location of where you're going to meet up at to make it easier for the other person to get there, what have you. So in legal cases, there might be reasons to change the venue, such as concerns about impartially or convenience factors, like we said. So in the court, this is called a change of venue, and it can happen if it's believed that a fair trial is not possible in the original location, right? So the cool thing about this is this is not the etymology, and it's not like the official understanding of how the word revenue came about, but for me, it helps better understand the word revenue. So like if you got a business, right, you go to your accountant, you go to do whatever, right, and they're talking about your financial statements, and they're using this term revenue to describe what many people call money, or the currency, right, that you're generating. So the revenue can be looked at to represent what you brought in, right? What they're going to say is your income. What they may say is your income. And the reason why I like to point this out for entertainment purposes is that it has the word venue in it. And we discovered earlier that the word venue is about where it's residing, right? Or domicile. Like where is it right now? Where is it at? So when it comes to the money or the currency that flowed into your business, right? Just like the customer's changing a physical venue, the property, because remember the currency is property, right? Instruments, bills of exchange, all that stuff are property, right? It's changed its venue. So it kind of parallels between the legal concept of venue, the place where the funds was, and now the place where it is moving to. So in other words, the funds, which property, are changing their residence or where they reside, or the venue, which is revenuing, if I'm making up a word here, right? While it's not the official etymology, this kind of helps make sense of what the word revenue is, because it's the revenuing of the funds in that particular fashion. All right, so that's pretty much it. So if you guys only have time for this portion of it, I'm okay. Drop some comments on it. Let us know what your thoughts were. If this was helpful, share it with your people, like the video, etc., all other stuff people tell you to do. All right, now for the rest of you guys, let's get into this here, which is going to be Leroy versus Great Western Corp. And let me get this on the screen for you. All right, so Leroy versus Great Western Corp. We'll run through this real quick, and then we'll get to the good stuff. All right, so basically, here's the syllabus, as they call it. All right, this was an appeal from the United States Court of Appeals for the Fifth Circuit, and then so after publicly announcing its intent to make a tender offer to purchase shares of stock of a company having substantial assets in Idaho. Well, so basically what we're going to be able to do now, for those that this is why that's 7. I know we got a lot of critical thinkers here, but for those who didn't think, we're going to show you, we took venue, and if you're just joining us, go back and watch it from the beginning. But we took venue, we broke that down with the U.S. Code, with the Black's Law Dictionary, with the Civil Resource Manual, and we showed how to apply to a relationship, right? And we showed in business, and we showed how it potentially has some backing to help us understand better revenue when it comes to terminology and money or / currency, for those who know the difference between the two. All right, so what we're going to do now is we're going to move into seeing it actually put into play in a real court case from 1979. Okay, because this has the full audio and I like it. All right, so a Texas-based corporation in which also engaged in business in New York and Maryland filed an informational schedule with the Security and Exchange Commission, SEC, required by the Security Exchange Act of 1934 as amended by the Williams Act, and also filed documents in Idaho in an attempt to satisfy the state's takeover statute. So when Idaho officials objected to the filing and delayed the effective date of the tender offer, appellee brought an action in the federal district court for the Northern District of Texas against the officials responsible for enforcing Idaho's takeover law, seeking a declaration that the state law was invalid insofar as it purported to apply to interstate tender offers to purchase securities traded on a national exchange. The district court held that the personal jurisdiction over the Idaho defendants have been obtained under the Texas long arm statute, and that venue could be sustained under the special venue provision in subsection 27 of the 1934 Act, giving federal district courts exclusive jurisdiction of actions brought to enforce any liability or duty created by the act. The court then went on to hold that the Idaho takeover statute was preempted by the Williams Act and placed an impermissible burden on interstate commerce. Okay, so basically they were blocking, right? Is what they were saying. So the Court of Appeals affirmed, holding inter alia that venue was authorized by subsection 27 of the 1934 Act because Idaho's enforcement attempt by conflicting with the Williams Act constituted a violation of a duty imposed by subsection 28A of the 1934 Act. All right. So, which provides that nothing in the act shall affect the state's securities regulatory agency's jurisdiction over any security or person insofar as it does not conflict with the act, and that venue was also proper under 28 USC subsection 1391B, which permits actions not founded solely on diversity of citizenship to be brought in the district where all defendants reside or in which the claim arose, because the allegedly invalid restraint against appellee occurred in the Northern District of Texas, and that was accordingly the district in which the claim arose. All right. So, there's sound. Let's just get to the oral arguments here. I want to get to the good stuff, to the tennis match. But basically, this is the fight over where should the case be held, because the company's doing business in Idaho, New York, Maryland. This is Texas-based corporation, even though they're actually chartered in Delaware. You'll find that out, and the problems happen in different states that cause it to affect what's going on in this other state. So where do you have this conversation at, so to speak? All right. So now we have motive to move to the oral argument. All right. Let's get some popcorn and sit back and enjoy.
Against Great Western United Corporation.
Let's take a look. Let me move this up a little bit. They got a little bit of delay, and then they talk to some other case, and they're not gonna get to today. You know how that go.
I want to inform the counsel in the United States against
the Idaho.
If you at any time you wish.
All right.
Mr. Chief Justice.
Mr. Heiser.
And may it please the court. The Idaho official appellants in this case believe that the jurisdiction and venue issues that are brought here before the court are the most important jurisdiction and venue issues relating to federal court jurisdiction over state officials since the decision in 1908 in Ex parte Young, and that the issues on the merits of this case are very demanding, very interesting, in the interrelationship of federal securities laws and state securities laws in a system of cooperative federalism. This case involves an attempt
Federalism.
by the appellee, Great Western United Corporation, a New York Stock Exchange traded Delaware corporation with corporate offices in Colorado, executive offices in Texas, and which does business throughout the United States, to effect a cash partial tender offer for up to 2 million shares of the outstanding common stock of the Sunshine Mining Company, a New York Stock Exchange traded Washington State corporation with its principal asset, a silver mine located in the state of Idaho, its corporate offices in the state of Idaho, its executive offices in New York, and other substantial assets in the states of Maryland and New York. Though in this case, the proposed tender offer was initiated by Great Western United Corporation in Dallas, Texas, the tender offer was announced and disseminated through a New York investment banking firm, and the shares were to be tendered to a Chicago, Illinois bank. As far as timing is concerned, on Monday, March 21st, 1977, Great Western United Corporation simultaneously filed a Schedule 14D statement with the Securities Exchange Commission as required by the Williams Act Amendment to the 1934 Securities Exchange Act, which relates to cash tender offers for corporate control. It voluntarily appeared in the state of Idaho to file a registration statement under the Idaho Corporate Takeover Law, which is the subject of the constitutional challenge herein, and it inquired of the states of Maryland and New York as to whether those states would exercise jurisdiction under their respective state takeover laws. 4 days later, that Friday, the Deputy Administrator of Securities of the state of Idaho responded to Great Western United requesting additional information under the Idaho filing, and contemporaneously, Appellant McEldowney, the Director of the Idaho Department of Finance, submitted an administrative order delaying the effective date of the tender offer. No other official from any state, including Appellant Kidwell, who has been replaced in office by Appellant Leroy, took any action or threatened any action. They were merely officials who were charged under their respective state laws with administering those respective state securities laws. Nor did Great Western United ever attempt to negotiate or respond in part to the request of Idaho for additional information, despite the fact that one of those requests was merely that the 8 missing pages from the Xerox copy of the 14D statement, which had been filed with the SEC, be submitted. Instead, Great Western United's sole response to the request for additional information that was received by them on a Friday was that next Monday morning at 9 o'clock in the morning to appear in federal district court in the Northern District of Texas, Dallas Division, seeking an ex parte temporary restraining order in a lawsuit which challenged the constitutionality of the state takeover laws of Idaho, Maryland, and New York, and asserted that personal jurisdiction and venue were proper over the state officials challenged under the ex parte Young stripping doctrine in the Northern District of Texas rather than in their home states.
Was the sole basis of this claim the fact that the federal law preempted the Idaho law?
No, Mr. Justice Rehnquist, the basis for the constitutional challenge was preemption on the one hand, and on the other hand, that the Idaho law and the Maryland and New York laws unduly burdened interstate commerce and were therefore forbidden on that ground as well.
I suppose the mere existence of an Idaho statute which might ultimately be determined to be preempted by a federal statute wouldn't mean that the state official charged with administering would be, quote, violating, close quote, the federal statute within Section 27.
Mr. Justice Rehnquist, that is exactly our contention. We have a situation here where the officials involved were themselves regulated.
And as always, even though this is we presented some of the things here that are mentioned, but just take note of the conversation, the assets that they're delivering at their disposal, like different codes and different subsections, and just jot them down, and go review them in the future for yourself. Get familiar with them, right? Because like I said, the reason I do this sort of stuff is because, for example, when the people had a problem with police shootings, and we saw how they acted, how the United States acted on both sides of that. The amazing thing is, if we just all knew what the word driver meant, we could reduce police shootings in what you think is the United States by 80%. Because when you look at the statistics, 80% of police shootings start in a traffic stop. So some book somewhere said that our people perish through the lack of knowledge, right? I'm just sharing some entertainment with you guys that's centered around knowledge. All right. Maybe one day when I get the budget, I can put some strippers in the background or some twerker. We'll have some people performing in the background, to keep other people's attention, because what we need to do is we need to reach a critical mass. All right. The reason why our communities is losing is because we haven't yet reached critical mass. And why I'm saying that is because why that's important is because this is not the time for anybody to feel like they're better than or more privileged than because of access that you have, right? No matter how you got it, over the next person. Because if we had already reached the critical mass, the nation as a whole wouldn't be experiencing the issues that we have right now. So obviously we still need an influx in the number and the detail of the informed. And we need a destination, not direction. Everybody's on here trying to give you direction. They want to be seen as telling you what to do. I'm telling you where to meet me at. I'm telling you where we need to meet. I'm going to let you know the venue. Okay? Because then you don't have to convert to something that you may or may not be wanting to do or be or whatever. You can be you, and let's figure out how to incorporate you, your brand, your business, your thought process into the nation arriving together. It's really disappointing when everybody waits to moments like Israel and Gaza, when we were talking about stuff like that the whole time. They didn't want to hear it, right? Now everybody's concerned. Now some of you see more like how it could be here next so easily. Let's get back to it.
Of securities transactions, and are being sought to be held under the jurisdiction and venue portion of the Securities Exchange Act of 1934 to be subject to suit under that, as though they had participated in fraudulent activities or had in fact violated some direct command of the Securities Exchange Act. That is the federal securities law basis for jurisdiction. That is correct. Mr. Justice White, the other basis for jurisdiction was the Texas long-arm statute. And under the Texas long-arm statute, it was alleged that the Idaho and other officials were actually doing business in Texas. And doing business is a jurisdictional prerequisite in that statute. It has a two-step analysis that must be reached. The statute defines two categories of doing business. One of those categories, strange as it may seem, is a tort that occurs in whole or in part in Texas, but that is defined in there as doing business.
Tort just means
the other
injury.
aspect of doing business in Texas under the Texas long-arm statute that is
Or
defined
wrong.
is
Like a wrongdoing or
contract,
injury.
the performance of which occurs all or in part in Texas. Then the statute opens up the scope and it says that it encompasses other activities that may constitute doing business in Texas. And it is very much the appellant's contention that their activity in a governmental capacity in being in Idaho as Idaho officials charged with and administering Idaho law is certainly not an activity of doing business in Texas with the commercial overtone that that doing business concept necessarily implies. That is the threshold consideration that must be reached in the Texas long-arm statute for assertion of personal jurisdiction. The next requirement for inquiry is, of course, the constitutional due process question. International Shoe, Hansen versus Denkla, again phrased in terms of minimum contacts, activities that are commercial, profit-oriented activities that would subject a company or organization or person engaged in interstate commerce in a profit-oriented mode to be rightfully subjected to jurisdiction in a place where the consequences of that commercial activity were felt. And we submit that the basis of this Court's determinations in due process really relate to the fact that the entity or person subjected to the jurisdiction of the out-of-state forum has been one who has sought the profit orientation of commercial activity. Never before has it been applied to a state official who is merely a regulator. And in fact, the mischief of it being applied really relates to a question that was earlier posed this morning by Justice Marshall about being sued in Maui. And while it may be nice for a state official to be able to vacation in Maui, it certainly is difficult when a state official would be called to defend his action in Idaho, in enforcing an Idaho law in Idaho, in Maui, or in any other place. The chilling effect that that would have on the enforcement of state laws, the chilling effect that that would have on legislatures in determining what law that they passed might be deemed to have somewhere in some other jurisdiction of this United States an extraterritorial effect or consequence would be incredible. And the budgetary problems that defending in a foreign jurisdiction present are also potentially overwhelming. The cost of sending attorneys and officials who were hired by their state to represent activities within the state, sending them to foreign jurisdictions to defend actions, the expense of the legislature in a small state such as Idaho trying to figure appropriations that would cover defenses in jurisdictions throughout the United States.
See, everything we just went over so far, we're looking for the argument of making it convenient for all as possible, or you know what I mean?
Of allegations that are brought merely because someone feels they've been affected in a foreign jurisdiction, and the expense in many of the federal districts of the United States where a person cannot be admitted directly to practice before that federal district, but must have, you sometimes can appear pro hac vis with associate counsel, local counsel. In other instances, you cannot be admitted to practice before that district at all, and you must hire local counsel.
Mr. Heiser, what if this case had arisen with a plaintiff as one who was contending that the takeover should not be permitted because the corporation had not complied with the Idaho statute? That plaintiff lived in Texas, otherwise had standing. Is there any reason why in that sort of a lawsuit where the Idaho officials weren't joined as parties, the district court in Texas couldn't hold that the federal statute preempted the Idaho statute?
Mr. Justice Rehnquist, if it were procedurally proper to entertain the lawsuit in the Northern District of Texas, there is absolutely no reason why the Idaho law could not be assessed as it affected someone in the Northern District of Texas. That is correct. But that is not what happened here, unfortunately, and of course we contend that had this lawsuit been brought in the District of Idaho, as it should have been, there would be no question that it is a lawsuit that is properly entertainable in federal district court in the District of Idaho. Unfortunately, it was not brought there, and that is what poses the very difficult jurisdiction and venue overlay to this case.
New York and Maryland would, on your basis, would have the same objection to jurisdiction in Idaho as you are are objecting to in Texas.
Mr. Justice White, that is absolutely correct, and in fact, New York and Maryland very strenuously did object to the jurisdiction and venue being based in Texas, as I'm sure they would have had it been based in Idaho.
But you wouldn't go so far as to say that, given all the other necessary requirements of federal jurisdiction and venue, only the federal district court sitting in Idaho could hold an Idaho statute preempted by a federal statute.
No, Mr. Justice Rehnquist, that is not what that would not be my contention. Under proper jurisdiction and venue in raising the federal question, it would be proper for a federal court to consider the Idaho law or someone else's law, and it might there might be a situation like that where Idaho would participate as amicus curiae and volunteer to come down. I'm not saying that there's a restraint on the court in entertaining the Idaho law. In fact, I think there's ample Supreme Court precedent for that occurring. There has been an allegation made that the state of Idaho delayed the effective date of Great Western's tender offer for the shares of Sunshine Mining Company stock, and that it therefore interfered with the transaction of $31 million of interstate commerce. In fact, the delay attributable to action by Idaho was for a period of 2 days, from March 28th to March 30th, 1977, when, after hearing that there was an ex parte temporary restraining order sought, we...
Now think about this for a moment. They brought up the fact that they $31 million was delayed by 2 days. Which, if they're bringing it up, they're probably seeking some sort of compensation for that, right? So, have you ever in life been in a situation where you were waiting on a refund, a credit back, anything like that? You know, any of those customer service calls where they told you, well, we're doing all we can for you. So, does this mean that if we had a great understanding or a much better understanding of what they're talking about here, it may apply to some of your headaches? Now, of course, you're not going to it'll probably cost you more to contest some of the issues. Like, you're not going to take it to the Supreme Court over a $5 credit, right? But just notice that they brought up their $31 million transfer was delayed by 2 days. So just think about that the next time an entity or such wants you to feel like you need to continue to wait for various reasons for what's due to you. Okay? And for entertainment purposes, explore that notion when it applies, or when it may be applicable, right?
Asked the federal district judge in Dallas to allow us to go on the record, and he postponed the hearing for 2 days. All the other delay in this case either resulted as from a lawsuit that was brought by Sunshine Mining Company in the District of Idaho against Great Western United under the Williams Act, charging that Great Western United had not complied with the Williams Act and the other delay was occasioned by Great Western's desire to pursue in the Northern District of Texas this constitutional challenge to the Idaho, New York, and Maryland takeover statutes. We have additionally the venue problems. Venue was alleged under the Securities Exchange Act of 1934, Section 27, and venue there was sought on the basis that the violations that were alleged to have been committed by the state officials actually occurred in the state of Texas rather than in the state of Idaho, when in fact the action that did take place was action that was taken in Idaho pursuant to the Idaho law, was transmitted to Texas at the request of Great Western United, which had sought the response to be sent to them in Texas. So it may have come to rest in Texas, but it took place in Idaho, and it, of course, creates the awkward situation that if you say that for venue purposes you have properly a single federal district for venue purposes as the place where the violation occurred, rather than a place where acts in furtherance of a violation occurred, which is not what the venue statute says, then you create this strange situation where if venue is proper in the Northern District of Texas, then it cannot be proper in the District of Idaho, and what you're really challenging is the action of the Idaho officials, the Idaho law, and the constitutionality of the Idaho law.
Let me ask you a question in two stages. First, suppose the Idaho company borrowed money from a Houston bank in Texas, and as usual submitted financial statements and defaulted on the loan, and suit was brought. Where would venue lie in Texas?
Mr. Chief Justice, under the terms of the Texas long-arm statute, where you had defined within the doing business context of that statute a contract to be performed in whole or in part in Texas, it is quite likely that the federal district court in Texas would have proper jurisdiction over that action so long as it did not fall within the proscription of the U-Anchor Advertising Incorporated versus Burt.
Now eliminate the Texas statute from the hypothetical and have the same loan made, financial statements submitted, and it turned out that the financial statements were allegedly false. Would venue lie in Texas independent of the Texas long-arm statute?
Under the general venue statute, Your Honor? Under the general venue statute, venue would be proper where all the defendants resided or where the act, the act or transaction that is the subject matter occurred. And in this instance, while the loan was sought in Texas, it would appear from the hypothetical you oppose that the default occurred in Idaho, and a venue would therefore be proper.
The false statement was delivered to Texas, to the bank, the lender. Isn't that enough?
That is, you have there a situation of a weight of contacts problem, where one of the acts in furtherance, if that is the operative fact, the false statement and its transmission into Texas, then yes, there are cases which hold that venue would be proper in Texas, although under a weighing of contacts analysis it might also be deemed proper that venue would be laid in Idaho. If that were
no question about it being in Idaho.
Well, it would be in Idaho under defendants, where the defendants resided. But as far as where the act or transaction occurred, I think that you could have it either in Idaho or in Texas where there is a deliberate fraudulent activity, because in that context which you pose, Your Honor, there you have a deliberate action by the defendant which he wants to have a jurisdiction-causing effect in Texas.
Mr. Heiser, are we talking now about venue or jurisdiction, and are we talking if jurisdiction over the person or over the subject matter, and are we talking as a matter of what's permissible under the Constitution or what is provided by a state statute? I've been lost in this discussion.
Mr. Justice Stewart, that has been one of the problems of this case from the beginning.
Well,
it has been our contention that there are several distinct criteria which must be met. That there are three criteria which must be met.
What, under the Constitution or under some state
must
statute?
be met under the Constitution as well. Well, there are criteria that must be met under the Constitution.
Yes.
Due process standards.
Yes.
There are three criteria which must be met under the Federal Securities Act jurisdiction and venue provision, and there are special criteria which must be met under the Texas long-arm statute. Under the Securities Act jurisdiction and venue statute, there must be subject matter jurisdiction. It has been alleged that there is subject matter jurisdiction because the state officials in enforcing or being charged with the enforcement of a state law allegedly in conflict with federal law rises somehow to the dignity of a violation of the Securities Exchange Act of 1934, and that therefore there is subject matter jurisdiction. Next, it has been said that there is personal jurisdiction over the officials because the action that they took was having an effect on a corporation in Texas, and that venue was proper in Texas because that was the district where the effect of the action in Idaho was felt.
It's personal jurisdiction over the Idaho officials, which is the big threshold issue here, isn't it?
Absolutely,
And
Your
it's
Honor.
personal jurisdiction over them, not subject matter jurisdiction over the case. Personal jurisdiction over the Idaho officials, whether there is under the Constitution of the United States, whether there can be. Isn't that it?
Mr. Justice Stewart, that is absolutely correct. There is one additional problem with that, in that the personal jurisdiction that was alleged under the Securities Exchange Act of 1934 was alleged because of the further allegation of subject matter jurisdiction in that they violated the Act. Because
let's
of
assume they violated the Act. It's still a threshold question.
There still is
whether or not the court had personal jurisdiction over
Absolutely,
them,
Your Honor. And under the Texas long-arm statute, that is the crux of the contention.
But if there was a violation, there's nationwide service, isn't there?
Mr. Justice White,
Let's just assume there was a violation by the Idaho
Nationwide.
officers. I don't suggest that I think there was. Doesn't the securities law provide for nationwide jurisdiction service?
Mr. Justice White, that is correct. It provides for nationwide service of process.
Wouldn't that give personal jurisdiction?
That would give personal jurisdiction in a court where the due process standards were properly applied.
Right.
And there again, we go to the crux of the argument. It has been the contention advanced sometimes in the case that due process does not obtain in an action such as is brought under Section 27 of the Securities Act because there is nationwide service of process, and therefore a state official can be served anywhere where a court can issue that process.
Anybody can be served by a federal court within the metes and bounds of our nation.
Absolutely, Mr. Justice Stewart. Anybody can be served by the court, but the threshold question there is that the proper court to issue the service?
Well, then
and that's the crux of it.
That's a matter of venue, then?
Yeah, that's true.
That is a matter of it's a matter of whether one wants to call it venue or proper assertion of personal jurisdiction. It is whether that is the proper court. That's the purpose of trying to stop the forum shopping.
Well, what if Congress says in so many words that if there has been a violation of the Act, as Mr. Justice White's question to you assumed, process may be served and personal jurisdiction may be obtained in any one of the 93 judicial districts in the United States?
Mr. Justice Rehnquist, if that is what the statute said, then I would still try to be here before you saying that statute in assessing personal jurisdiction on such a broad scope was missing the very important due process requirement that allows the federal court to hear the case in the first place.
Even in a case where the prosecution or the action arose in a case where the alleged violation occurred?
Mr. Justice White, no.
Of course you would.
That's the whole point.
So if the violation occurs in State A and the federal law says that you can serve anybody connected with this case anywhere in the country, you wouldn't object to that?
Absolutely not, Your Honor, and that's the whole point. If this were brought in the District of Idaho, and for some reason the Idaho officials had to be served in Hawaii or Alaska or wherever, nationwide service of process, absolutely no problem whatsoever.
And that doesn't determine where the venue is going to lie.
That's correct, Your Honor. That's where the claim or the act in violation occurred, is to where the venue of.
And go back to the beginning when we were talking about, no matter where they decide to have the case, where they're talking about services being served so that they can be known that they need to come, court case is going to be there. So they can have the trial there, and it doesn't matter where the people are. So yeah, it might have been convenient. Let's say if everybody was in Texas, it might have been real convenient to have the case in Texas. But they're gonna put it, if they went and put it in Idaho to begin with, they would have notified everybody in Texas, even though all the witnesses and all this stuff might have been in Texas or whatever, that they need to come to Idaho for this case. You see what I'm saying? So again, do the research to see what best applies to what gives you the best chance to be able to win, and make that push to wind up there on your behalf. You know what I mean? Same thing in conversations, same thing with your conversations with your spouse or a business or whatever. Start to look at these tactics, even though they might be used here. What would it look, feel, sound like, smell like when you use them in conversation that you have every day, right? Because once we start practicing this on a daily basis, one, you're going to find yourself possibly more isolated, because the people that like bullshit aren't going to be able to bullshit you as much, or they're just not going to be able to bullshit around you as much, right? Because you're not going to entertain it, because they'll get stressed out trying to overcome your presentment, so to speak, right? So I don't want to break up any relationships or anything, but this might cause you to become single. Some of you guys, that might be a good thing, because you don't realize how you're being manipulated until you understand the conversation and how, So let's continue.
The case is laid.
All of this colloquy is addressed to the federal statute, is it not?
All of this is directed to jurisdiction under Section 27 of the Securities Exchange.
The Texas statute, isn't it?
That was one basis for jurisdiction. The one basis for jurisdiction over the state officials was Section 27 of the Securities Exchange Act of 1934. The alternative basis for jurisdiction over the state officials was under the Texas long-arm statute and its accompanying venue statute. So what the two courts below found was that jurisdiction was proper in the Northern District of Texas by coming down these two avenues.
Well, don't you agree that if your opponents can sustain either one of those, the Court of Appeals was correct?
Mr. Justice Rehnquist, if this court would sustain either one of those, then the Court of Appeals was correct. But
they're independent bases of jurisdiction.
Absolutely, Your Honor. But it's our contention that both of them are absolutely wrongly decided, because both of them misapplied not only the due process standards, but failed to come to grips with the doing business prerequisite on the one hand in the Texas long-arm statute, and created this incredible fiction that state officials who were enforcing a state law in Idaho themselves regulators of securities transaction, were somehow guilty of the same type of activity that people who are subject to the Williams Act and the other portions of the Securities Exchange Act violate.
That's answering the question that Mr. Justice White earlier asked you to assume. So supposing that they go into the Northern District of Texas and allege that you have violated the section of the Securities Act and alleged venue and jurisdiction under Section 27. Now, don't you think that Congress has a right to allow that sort of jurisdiction and venue if it expressly says so, and if it can if the plaintiffs can satisfactorily make out a case that you have violated the thing?
In Texas.
In Texas?
Mr. Justice Rehnquist, yes. If the prerequisites that you say, if there has been a violation, truly a violation, if the statute were framed in such a way, the underlying law were framed in such a way that a violation truly could be said to have occurred, yes, the Congress can structure it how they want to.
Insofar as you're having violated the statute or not, and I don't suggest one way or another, your position or your status is the same in Idaho as it is in Texas. You have violated it in Texas just as much as you have in Idaho, but no more nor no less.
You have violated it, Mr. Justice White, any place in the United States.
Exactly.
But venue would not necessarily,
if
you have violated it all, but venue would not necessarily be proper in the United States. Then you're back to venue. I reserve the rest of my time.
Before you sit down, just a detail, is the Attorney General properly here?
Mr. Justice Blackmun, it's my contention the Attorney General is properly here. The decision of the Fifth Circuit Court of Appeals, although the Attorney General did not make the formal appeal from the District Court decision, at all times in the context and in the writings of the Fifth Circuit, it treated the officials in the plural as though both of them were before the court. It affirmed the decision of the court below that related to both of the officials. And it's our contention that the Attorney General is properly before this court because the Fifth Circuit, wrongly or rightly, certainly did assert jurisdiction over him and adjudge the case with regard to him.
Speaking of Attorneys General, I think in your brief you have ex parte Young as the Attorney General of Minnesota. Sometimes we in Minnesota might be glad to yield that to Michigan, as you described him, but or one of the briefs did, I think yours.
In the summary of argument, in the summary of argument, my printer got Michigan in there. In my argument, he did it right in Minnesota.
Mrs. Jubiler.
Bang. Mr. Chief Justice, and may it please the Court. The unprecedented decisions below with which you have just been grappling with Mr. Heiser changed the law with regard to
she's cool. She's real animated with her
so as
stuff.
to expose the states, their officials, and the laws enacted by the citizens of this country through their state representatives to unfair trial as occurred in this case. There was no reason whatever, none, to warp the established procedures to accommodate Great Western United, a multi-state corporation seeking to expand its Idaho operations. Suit in the district court in Idaho was possible and was convenient for the defendants, as we demonstrated in our brief. The only reason that these problems are presented to Your Honors, that of subject matter jurisdiction under the Securities Act, personal jurisdiction under the Securities Act and the long-arm statute, and the limits on those statutes posed by due process, and the questions of venue not only under the general venue statute of this Court, in issues that have never been presented before, and venue under the Securities Act. The only reason was that because the lower courts were impatient to exercise their own jurisdiction, the personal jurisdiction of the Northern District Court and the jurisdiction of the Fifth Circuit, in order to decide a superficial and intellectual question only, and that is whether the law of Idaho was preventing shareholders of Sunshine Mining Company who personally resided in other states from selling their shares to Great Western United. Those shares, we must remember throughout this case, were in a company whose major asset is the largest silver mine in the United States and a very important resource of the state of Idaho, and permanently located in Idaho.
Mr. Jubiler, your friend, Mr. Heiser, in response to Justice Blackmun, said very definitely the appellant is here. Could he have taken an appeal to the Court of Appeals from the district court judgment? Could he? We know that he didn't, if I recall it correctly.
Yes, Mr. Chief Justice, I believe that Appellant Kidwell could. That's an interesting question to pose to the representative of the Attorney General of New York, who sat in our office and debated whether we could take an appeal because we had to expend public monies, and may I say my own private funds, because the comptroller didn't think that I was really on state business in Dallas and New Orleans. He thought I was on some frolic and detour for my own amusement. Also, the people who provided us the transcripts have similarly suffered the skepticism of the comptroller of the state of New York. But we determined that we wouldn't burden this court with yet another jurisdictional problem in a case already bothered, and we chose not to appeal but to appear as amicus throughout, although we feel personally aggrieved. The Attorney General feels personally aggrieved for having to defend his statute in Texas when there was no reason whatever to do so, leaving aside all of the legal objections in the Constitution. Along the way, in doing this, we're not only dealing here with statutes that failed to provide jurisdiction and venue over the state officials, but the policy that is reflected by Congress's utter lack of interest in securing this kind of jurisdiction over state officials is part of the way our government is organized. I'm not going to go so far here because it is unnecessary to say that if Congress wrote the kind of statute that Mr. Justice Rehnquist was talking about, it would be unconstitutional as a violation of our federal rights. We'd first have to see it. Or perhaps unconstitutional as a violation of due process of the individual state officials sued under the doctrine of ex parte Young as to whether they were given adequate notice that they would be exposed in foreign jurisdictions for their actions in good faith compliance with their own laws.
You don't deny that a private citizen could be made subject to suit anywhere in the United States by Congress, do you?
No, of course, Mr. Justice Rehnquist, I don't deny that it would be possible for Congress to establish nationwide service over state officials if the statute not only gave full notice, but was based on some reasonableness and the action also had some basis in the jurisdiction in which
But if Congress just said in so many words, there should be nationwide service of process on everyone who is alleged to violate this statute, when didn't purport to make any finding of reasonableness, they just, this is what the law is going to be.
If Congress had done that, and well, one of the basic questions, you use the word violate, and it has been used here a great many times. It is not conceded, and I think it is does not do credit to the language of the statute. The states are not violators. The language for a state statute which is in conflict with the Williams Act or with any other aspect of the securities law is precisely that conflict. The word violation does not fairly apprise a state official that what he does is in conflict, or in fact, if someone sought to sue an official of the Securities Exchange Commission under the same grounds, I don't think he would be given due process notice that he would be exposed to suit as a violator, unless Congress also said a violation means that you act in conflict with this statute. And then I think if Congress did that, securities administrators would know that a new era has come into the United States, and state statutes governing securities, instead of giving the heavy presumption in favor of them that they are presently given, now are to be treated as substantively suspect. And without And because we have a procedural system that reflects the substantive law of securities regulation in this country as well as corporate regulation, one can expect that an ordinary state statute which governs the affairs of corporations within that state, actually within that state, and the affairs of securities trading regarding such a corporation, such a statute is presumed correct and is not presumed to be a violation unless Congress held hearings and thought about it a lot and did it. But Congress hasn't threatened us with that, nor is there any suggestion that Congress went so far. And all of this, Your Honors might want to manipulate, as the courts below did, the law to get at the issue if there wasn't a court sitting that could get at the issue. But we've conceded from the beginning that there was subject matter jurisdiction under the Supremacy Clause under 1331, and subject matter jurisdiction was available in Idaho. Furthermore,
you know us better than to think we would want to manipulate, don't you?
I used the wrong. Well, we feel that it's very difficult to look at the decisions below and not think that the laws of jurisdiction and venue have been manipulated. Not one single decision has a direct precedent. Nothing in the finding jurisdiction and venue over the defendant here has a precedent in any previous decision. None of it is required by the language of any statute except by interpretation that is overlaid and is not supported by precedent. Just as an example of the most minor aspect of the venue decision of the court below, look what it did to a multi-state corporation doing business all over the country. Suddenly, it can now sue where its board of directors reside, even though it's conceded it was doing business in Idaho and it was its Idaho business that was at issue. Suddenly, in a federal court, venue now lies for this kind of action in Texas, and the court below implies that that's the only place that can lie. That applies not only to actions against state officials, but to actions against federal officials and to actions against people who have commercial dealings with Great Western United. Indeed, when Sunshine Mining sued Great Western under the Williams Act in the District of Idaho, sued Herco, the successor company, after the completion of this tender offer, Great Western United said, oh, no, you've got to sue us in the Northern District of Texas. We have special rights. We can only be sued in the Northern District of Texas. We now own controlling interest in Sunshine Mine, and your cause of action is about Sunshine Mining Company, but we get sued where we live in Texas. This does terrible violence to the system that has been established by, for instance, the Texas long-arm statute, and also, for instance, by Section 27. Nationwide service of process under Section 27 has a purpose, and its purpose is to make Great Western United be serviceable where its securities are issued, and Sunshine Mining be served where its service is issued. It does not have the purpose of making the officials of Idaho enforcing their own state statutes serviceable where their decisions may have an effect. The precedential effect of that kind of decision below is overwhelming. And for those of us who represent state officials with regularity, we know that this will change radically the way that states are able to defend themselves.
Time has expired now, Mrs. Gerber.
Thank you very much.
Irwin.
Mr. Chief Justice, and may it please the Court, I represent here the interests of Great Western United Corporation, the appellee. In March of 1977, as Mr. Heiser has stated, Great Western United Corporation proposed an interstate tender offer for shares of stock of Sunshine Mining Company. Great Western is a Delaware corporation with its headquarters and principal ownership in Dallas, Texas. Sunshine Mining Company was and is a Washington corporation with business operations in Idaho, in Maryland, and in New York. And I mention the fact that Sunshine had its place of incorporation in Washington because Washington had and has no state takeover statute. The shares of Sunshine stock were held by citizens across the nation, about 2.5% residing in Idaho, about 6% in Washington, some 7% in Texas and elsewhere. Shares were listed and traded on the facilities of the national securities marketplace. Great Western was proposing to pay a premium over the market of $15.75 per share for up to 2 million of those shares. With that backdrop, Great Western complied in all respects with the provisions of federal law governing the regulation of interstate cash tender offers pursuant to the Williams Act amendments to the Securities Exchange Act of 1934. Nevertheless, because Sunshine had operations in these other 3 states, Idaho, Maryland, and New York, and each one of those states had a state takeover statute, Great Western could not make the offer upon filing with the Securities and Exchange Commission its Schedule 13D, now a 14D1. The Idaho Act, which is typical of state takeover statute, contains an express extraterritorial provision which states that no tender offer can be made for shares of a target company as defined in the Act anywhere, that is anywhere in the world, to any shareholder until the Idaho statute has been complied with. Now, the extraterritorial application of that statute, combined with the fact that Maryland and New York had similar statutes, constitute the most critical facts which permeate all of the issues before this court this day.
And the coverage of the Idaho statute was of corporations with their principal place of business in Idaho, corporations incorporated in Idaho, and what else?
Having substantial assets in Idaho.
And this is principal place of business.
This was principal place of business and assets. There was an office as well as the mining operation.
No question as to the coverage.
No question but that it was covered. But I also would make the point that the triggering mechanism of the Idaho statute was not the presence of any Idaho shareholder of Sunshine. It was rather the business contacts between Sunshine and the state. I feel that I should turn to the questions of jurisdiction and venue because that was all that was opened with. And if I'm...
Ask you a question?
Yes.
I understood you to say that the Idaho statute was typical of these state statutes. In your brief on page 20, the first sentence under summary of argument is, unlike any other state statutes.
Any other state statutes other than state takeover statutes. I'm sorry, Your Honor.
Right.
Certainly.
So you say this is typical of the 22 or 25 other state statutes?
I think all but about 5 have this same extraterritorial reach, and I think there are 32 states now which have state takeover statutes. The district court had personal jurisdiction over this case, and venue was proper. Great Western had 2 avenues available, as has been discussed. One avenue was utilizing the general venue statute, 1391B, and the Texas long-arm statute. The other avenue, if we had subject matter jurisdiction under the 1934 Act, an issue, of course, which is being controverted, was through the nationwide service of process under the provisions of Section 27 of the 1934 Act and service in accordance with Rule 4.
But even there you had to show that the defendant was, quote, found, close quote, did you not?
I had to show under Section 27 that an act or transaction had occurred within the district which constituted a violation or breach of duty.
Well, will you turn to page 6 of the jurisdictional statement, please, where I believe Section 77 of the Securities Act is sent out. The district, it begins on page 5 and ends on page 6.
Yes.
And it talks first about criminal proceeding, and then it says any suit or action to enforce any liability. This is beginning at the top of page 6. Or duty created by this chapter, or rules and regulations thereunder, or to enjoin any violation of such chapter or rules and regulations may be brought in any such district or in the district wherein the defendant is found. Now, you say that that you can bring it in a district where the defendant is found, or in such district?
In any such district, referring back to the lead-in sentence concerning a criminal proceeding may be brought in the district wherein any act or transaction constituting the violation occurred. Now, that's the criminal proceeding.
So then you say the civil adds on is broader than the criminal.
It refers back to the criminal district as one place and then goes further. And the criminal district is where the act or transaction complained of occurred. As I was saying,
but you're going to tell us what the violation was, aren't you?
And breach of duty, if it may be characterized that way.
So you are going to tell us just
yes,
what it was? Yeah.
Yes. Would you like me to do that now or wait?
Yeah, I think it's kind of the heart of the case.
All right. Section 28A of the 1934 Act addresses itself specifically to the question of what securities regulators can do. It reserved to state securities commissioners or their counterparts the jurisdiction within their states over securities transactions so long as the activities of those commissioners was not in conflict with federal law. The language itself speaks in terms of jurisdiction is preserved as long as it doesn't conflict. Thomas Corcoran, one of the principal draftsmen of the 34 Act, stated at the time that Section 28A was adopted that the purpose was to establish and to utilize traditional preemption under the Supremacy Clause. The statement was that the state may legislate in addition but may not legislate inconsistently, which is the very foundation of the Supremacy Clause. It is our view that the attempted enforcement by appellants in this case of a statute which conflicted with the substantive provisions, the disclosure provisions, and indeed the approaches of Congress as expressed in the Williams Act amendments constitutes a breach of the very affirmative duty which was placed upon securities regulators not to enact statutes which conflicted.
What affirmative duty was placed on them? Are you talking about 28AA?
Yes. Yes.
Well, I would not read that as placing any affirmative duty on them. It says nothing in this chapter shall affect the jurisdiction except such and such. Now, that may negate their right to do a particular thing, but it certainly doesn't place any duty on them doing it.
I would view it differently. I would view it in terms of, as the Fifth Circuit said, the Commerce Clause is expressed only as an affirmative grant to Congress, but it contains self-executing restrictions on state power.
You're saying an officer who tries to enforce a state statute that is in conflict with a federal statute is violating a duty under the federal law.
Under the 1934 Act. If it is a statute which conflicts with the federal law as embraced within the Securities Exchange Act of 1934.
in terms you had the right to be free from state regulation.
Well, I think the shareholders of Sunshine had the right to be free from regulation which blocked this tender offer until the state statute was declared unconstitutional.
So did your client, I take it.
My client, of course, wanted the opportunity. I'm not saying we had a right to make a tender offer free of state regulation. I think states can regulate in certain areas in tender offers. I don't think that this particular statute, with its infirmities, will stand constitutional muster.
Well, normally, if your company in Texas has a gripe against a state official in Iowa, they would litigate where?
It would depend on where the defendant was acting.
Normally. You'd go to where the person
Normally you would go to where the defendant is located.
And you attack the statute there, wouldn't you?
You could.
Is yours solely because of the Williams Act, or are you relying on both?
Well, we are relying upon constitutional privileges as well as a violation of the Act. And Well, I referred a moment ago to the extraterritorial.
Constitutional, you mean due process?
The Supremacy Clause and the Commerce Clause, which we believe the Idaho Act violates. I'm sorry.
You're not arguing due process.
I think there is some element of due process in here, but that was not specifically how we brought our suit. A state cannot regulate the affairs of another state. That is certainly a due process argument, which is implicit.
I understand the appellants. They say that's exactly what you're doing. That the federal court in Texas is administering the laws of Idaho, whatever it stands.
I think what the district court in Texas was doing was
but isn't that what they say?
Was making the determination
that the federal district court in Dallas is interfering with the laws and the officials of Idaho. That's their complaint.
And our complaint is that the Idaho regulators, by seeking to regulate extraterritorially, were damaging the plaintiffs, the federal plaintiffs who brought the suit in the Northern District of Texas, where the very restraint occurred. It's tit for tat. It's fair play. If the Idaho regulators stay at home and regulate within their state, they're only going to be subject to being sued in their state. If they purport to regulate for the rest of the world and say you can't make a tender offer, Great Western, you can't buy a single share of Sunshine stock from any shareholder anywhere until you come comply with our law and you have to route all this commerce around to us, then they should be subject to suit in the place where they caused their consequences.
And you would say if each of the other 50 states had exactly the same law and issued the same order, you think every state should be subject to suit in at least one place?
Yes, I do. Under the 1966 amendments to the general venue statute, allowing suit to be brought where the claim arose, for the first time the federal plaintiff could bring different multi-defendants into a single forum, just as we did in this case through the application of the general venue statute. We were faced with New York, Maryland, and Idaho at the incipient stages of this litigation.
And it's inevitable that if you spread that widely, it's going to be quite inconvenient for someone.
Very inconvenient for someone, and we do not think that any policy of judicial economy would be served by Great Western being required to sue one time in Idaho, one time in Maryland, and one time in New York, particularly when the focal point.
Well, how many states have takeover statutes?
Approximately 32 or 33. I'm not sure the exact number. Mr. Heiser says 36. I'll take his count.
That would just be 4 more suits for you.
Yes, right.
Mr. Irwin, of course, you don't have to have them all held unconstitutional in this transaction. I think
no.
Only 3 of them affected you. But the violation, getting back to the question I asked before, the violation I think it was committed when Mr. Bapty mailed the letter into Texas. Was that right?
I think it's a little broader than that. Mr. Bapty sent a letter into Texas which required the disclosure of substantial additional information over and above federal law. And 2 of the disclosures which he sought, if we had complied, would have triggered federal enforcement action. We would have violated federal law if we had complied. That's one point. Accompanying the letter was an order.
Right.
That order had been entered without any notice, hearing, posting a bond, or other security, which, as held by both courts below, restrained Great Western from going forward anywhere.
Well, now, did Mr. McEldowney, when he signed that order, violate the federal statute?
I think by seeking to enforce this statute, he breached the duty or violation, either one.
Did he commit a crime?
No, Your Honor. No, he did not commit a crime.
Well, yet you're relying on the such district language from 27 that provides for criminal jurisdiction, aren't you?
But it is repeated when the civil jurisdiction provisions of Section 28 come into play. The first sentence says, in the district where the violation occurred in criminal proceedings. Then it goes to, may also be brought, and this is the civil side of the docket as I read it, Your Honor, where the violation of a civil violation occurred, where the breach of duty occurred, or to collect a liability.
No, it says what may be brought in any such district or in the district wherein the defendant is found or is an inhabitant or transacts business.
You think refers back to any district in which a criminal violation could be prosecuted?
Where any act or transaction occurred, which would constitute the violation.
Do you think that would be limited by the vicinage requirement of the Sixth Amendment?
I'm not sure I
well, the Sixth Amendment says, as you no doubt know as well as I do, that in all criminal prosecutions the accused shall enjoy the right to speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Now, I take it that Congress is bound by that in allocating criminal jurisdiction under the Securities Act.
Yes.
And do you think a crime was committed in Texas, in this case by the state defendants?
No, I do not think a crime was committed. I do not, and I think it's important for me to remember and advise that there have been a number of cases where venue has been proper under Section 27, although there was no criminal violation involved.
From this court? You say
not in this court, but in the lower courts, and I think the reasoning of the lower courts is sound. In the 16B area, for example, suits may be brought under Section 27 to collect the profits which must be disgorged for illegal short swing trading, but there is no criminal sanction for such prohibited activity. But the lower courts have reasoned that it doesn't mean only that there has to be a criminal violation under Section 27. It can also be a civil violation or breach of duty or something that would lead to the enforcement of a liability. If I may, if I've answered that question, I'll get back to this question of the first route which we took, which was the general venue statute where the claim arose. We believe that the Northern District of Texas was the focal point of all of appellants' regulatory activity as well as that of Maryland and New York. Jurisdiction was obtained under the Texas long-arm statute, which has been definitively construed by the Texas Supreme Court, Uanker versus Burt, as going to the full limitation of constitutional due process. Judge Stakely, in writing for the Texas Supreme Court on that state issue, said that the construction does not involve technical and abstruse definitions of what constitutes doing business. The United States District Court, which heard this case, said the statute has no commercial import. Appellants would argue that they were not doing business. The statute uses doing business as a pickup to pull in every activity other than what is already specifically described, and as I said, goes to the full limits of constitutional due process. In any event, the duty, as the Fifth Circuit, the business of the Idaho officials, as Judge Wisdom said, was to regulate. Hearing oral argument has been held to be doing business. Now, I don't have this case in my brief, and I'd like to put it into the record. It's Wisconsin Telephone Company versus Wisconsin Department of Industry, Labor, and Human Relations, 228 Northwestern 2nd at 649, Wisconsin, 1975. We then turned to a minimum contact analysis under the long-arm statute. It seemed to us that the activities of the appellants were certainly purposeful. There was nothing accidental about the comment letter or the order which was sent in which restrained us. The results on Great Western were certainly foreseeable. You could certainly see that if they restrained us, it locked up the funds, lost the opportunity to go forward. The cause of action arose directly out of those activities of the Idaho regulators. The causing of purposeful consequences in a foreign district has been held sufficient under many applications of minimum contact analyses. The other avenue which we proceeded was Section 27. It's in a relationship with Section 28A, our view in the courts below that there was a violation or breach of duty by the enforcement of this conflicting statute. Therefore, minimum contact analysis was not required because we had from Congress the availability of nationwide service of process. The sovereign, United States, can exercise in personam jurisdiction over its inhabitants. There would only be a minimum contact analysis required if if we'd been seeking to sue someone outside of the continental limits of the United States and its territories. Under the Section 27 construction by the lower courts, the act or transaction does not have to be the core of any wrongdoing or even illegal, as long as it's something more than immaterial. Here, the most material aspect of the Idaho regulation was happened in Texas, that is, the order which enjoined us. And we would further say that even if a minimum contact or weight of effects analysis were proper under Section 27, it would be satisfied under the same analysis under the Texas long-arm statute.
Do you think Section 27 gives you the right to sue?
Yes.
You mean a so-called private cause of action?
We would think so. Great Western...
Do you have to find some section that gives you that right? In the securities law or not?
In order to have subject matter jurisdiction under the 1934 Act, we would have to find a section, yes.
Well, you're suing a state official, aren't you?
Yes.
For interference with what you claim is a federal right?
Yes. For violating the federal right, the federal regulation of tender offers as expressed in the Williams Act through a statute which conflicts.
Well, all this section says is that actions may be brought, any suit or action to enforce any liability or duty may be brought in some, but does that automatically say any, does that automatically provide for private causes of action?
I don't think it
under this entire chapter?
I do not think it automatically does. I think that...
What's your authority then for saying there is a private cause of action here?
It was Great Western's tender offer which was, in fact, stopped.
But don't you have to go back to find out whether Congress intended that you have a private cause of action rather than relating the facts of this case?
See, so that was a great use of the word authority. He said, what's your authority? Right? And remember that the word authority is the book or the quote that settles the question. So if we go back a second here. He answered that it was the Great Western's tender offer, which was in fact stopped. So this is why he's following up with speaking about Congress, because he wants to know what the authority is. Was the book or the quote that settles the question, which is why they're asking about the Section 27 to see what, and they were asking him earlier about, is he trying to say this was there a crime? You know what I mean? And he was like, no, it's more of a tort situation. So this is what they're probing for right now, the authority for him to move forward with this suit. So I'm just a fan of the word authority, because when you tell people that, they always think it's a person, not you guys, but a lot of people we talk to think it's a person, and when it's really the book or the quote that settles the question. So your supervisor or your whoever, they may have studied the book, they may have the authority in them, but it's really not them that's the authority. Okay, remember that.
Act stopped.
But don't you have to go back to find out whether Congress intended that you have a private cause of action rather than relating the facts of this case?
I see. I understand the cause of action. There have been implied causes of action under the 34 Act.
There have been. Have we ever held there was one under this particular section?
Not under this section, no. No, this is not. This is a case of first impression in that respect. I think it also may be important for me to bring to the Court's attention something I'm bringing late, but nevertheless, I think it would be something the Court would want to look at on its own motion. Idaho came here, appellants came here under the provisions of Section 1254-2, that is by way of an appeal, as opposed to making an application for writ of certiorari. That appeal invoked this Court's obligatory jurisdiction, and under the language of the statute precludes a writ of certiorari. The review on the appeal is limited to the federal questions. There is no authority on how wide that federal question issue is. We would submit it may be, and again I think this is a case of first impression, that the only federal issue is the validity of the Idaho statute, which was held unconstitutional, which furnishes the basis for the utilization of 1254-2. If that is so, then the provisions of the issues brought here on jurisdiction and venue are not the federal question which was to be reviewed under the provisions of 1254-2.
But if you had no right to sue as a plaintiff under this statute, then there was never any occasion to pass on the validity of the Idaho statute?
May I say that we were not basing our right to sue on just the 1934 Act. We were also basing our right to sue on constitutional privileges under the Supremacy Clause and under the Commerce Clause. There we felt we certainly had standing.
But then you certainly couldn't invoke Section 27 jurisdiction.
That's true. If we don't have standing to bring this action because of a violation of 28A, we can't use 27, and we have to go to the other alternative, which was the general venue statute plus the application of Texas long arm. That's correct. In brief fashion, I would ask the Court to bear with me for a moment on a preemption analysis very quickly. The Williams Act was brought into play in 1968 after Congress had been deliberating the subject for some 3 years. It was not an area which had been regulated before by either states or the federal government. At the time of the adoption of the Williams Act amendments, there was one state takeover statute, Virginia, which had become effective about 2 months before. Congress said it closed the gap in an area which had not been regulated. Cash tender offer phenomenon really didn't occur until the mid-'60s, or maybe early 60s. So this was not an area which had been traditionally state regulated. Congress took a market approach, allowing the tender offeror to make his filing and go direct to the shareholder at the same time that the incumbent management was going direct to the shareholder to tell their story, to let the shareholder make his informed decision about taking cash for his shares. As a result, Congress considered but rejected prior agency approvals, considered but rejected pre-effective filing requirements. Idaho took exactly the opposite course and has an extensive hearing and pre-filing requirement, which causes the very delay which Congress didn't want to happen because of the weapon it would give to incumbent management to discourage, delay, take defensive maneuvers to defeat a tender offer. Congress also did not seek to have the shareholder decision made by any fiduciary. Idaho took the opposite approach, where the tender offeror must satisfy either the target management and get their recommendation or the state regulators. And this particular statute suffers a further vice in that the incumbent management can determine whether the state regulator acts or not. If they accept the offer, the state regulator cannot call a hearing. If they do accept, if they accept the offer, he can't call a hearing. If they don't accept the offer, they have to call a hearing. The enforcement of these differing substantive and disclosure provisions between Idaho and the Williams Act and the difference in approaches as found by the majority opinion in the Fifth Circuit and by the United States District Judge demonstrates that this tips the balance of regulatory power in favor of the target management, which was not the policy Congress had in mind, and the Idaho statute stands as an obstacle to the full accomplishment and execution of congressional purposes. The preemption analysis was just one of the analysis that the courts below went through. It just tells one half the story. The Commerce Clause was also violated, we believe, by Idaho's direct regulation out of state of a cash tender offer involving some $31 million. Great Western and shareholders throughout the country could not do business with each other until the Idaho law was satisfied.
If the Idaho statute had been limited to intrastate activities, would it be preempted in your view?
I don't think so, because I think it would then operate like a state blue sky law, exactly, the constitutionality of which this court upheld in 1917 in Hall versus Geiger-Jones. effect of the Idaho regulation put Great Western to a Hobson's choice. We could either ignore the letter that came into the Northern District of Texas and the order and risk substantial civil and criminal penalties, or we could comply and accept the delay and the additional burdens and the jeopardy which would be caused. We chose to go forward with the lawsuit because we believed that the enforcement of this statute had interfered with the area of free trade, which had been established by the Commerce Clause, and that there were no legitimate local interests being protected. Idaho has stated in the brief that they're protecting shareholders, but that analysis is a little thin. The Idaho statute does not require the presence in Idaho of any Idaho investor in a target company. So the very class of persons Idaho says they're protecting don't have to exist. Even if, see, my time is up.
May I ask this question?
Yes.
Your complaint also alleged a cause of action under 1983.
Note, here, let me bring it back a little bit here. Note right here where he said, so the very class of persons Idaho says they're protecting don't have to exist. Just think about that statement for the United States in general. A lot of stuff we talk about here, just remember this statement. Whether you're on Facebook, YNet7, whatever. Remember this statement. So the very class of persons Idaho says they're protecting don't have to exist.
The presence in Idaho of any Idaho investor in a target company. So the very class of persons Idaho says they're protecting don't have to exist. Even if, see, my time is up.
May I ask this question?
Yes.
Your complaint also alleged a cause of action under 1983. What's the basis of that?
We believe that the delegation by Idaho under the Idaho Act to the target management of the right to determine whether or not the Idaho Act would come into play constituted an unlawful delegation to a vitally interested private party in violation of the Civil Rights Act as expressed in 1983.
What civil rights?
We believe that there is a discrimination involved if an outside party is subject to state regulation only at the behest of another private party.
You still rely on 1983?
We have not brought that forward in the brief, Your Honor.
Does that mean you've abandoned it?
We've abandoned it.
You haven't brought it forward in the brief, but it's in your complaint. It's a jurisdictional question.
Yes.
And aren't you claiming that you have a right under the federal securities law that's being violated?
Yes, but not only under 1983.
Well, I understand, but that refers to the federal constitutional law. And you certainly are claiming that one of your constitutional rights is being violated under the Commerce Clause.
Yes.
Well, and you're suing a state official.
Yes.
Right. And they're also claiming a violation of federal laws. 1983 speaks of constitutional laws of the United States.
Yes, sir.
You sure you're abandoning it?
I'll reinstate it.
Yeah.
See, that dialogue exchange right there, right? I like that for you guys. And you know, I wanted to interrupt some more, but I wanted to let you hear it play out. But I like that because what I want you guys to take note there is, no, it's not like I've done 150 cases myself, like, you know, me, but I've won 3 court cases myself. So what I found was, what I'm bringing this up for is to say this. I want you guys to start, and this is, you know, I'm not an attorney, I'm not a, you know, it's not legal advice. I want you to, when you have the opportunity though, to start practicing whether that's home among your family members, and eventually graduate to the point where you lose the fear, right? You lose the hate of the, and you go into the courts and present your own cases. Because when you learn how to speak non-emotionally and speak based on code, statutes, and the tools provided you to articulate the emotions that you may have, right? To make the impression that you're looking for. The people that you feel like you hate, or could be the enemy, the ones sitting aside those benches and tables, they give you a different, they respect the authority in you, is how I'm going to say it. Remember, the word authority is the book or the quote that settles the question. Think of it like this. When you go to the basketball court and you know how to play basketball, and then you got the one person that shows up and don't know any of the rules. Like, they're getting the ball, running down the court without dribbling, 5 steps for a layup, breaking all the rules, right? Imagine what it feels like to play the game of basketball with them. Despite whether they're right or wrong, whether the ball goes in the hole or not, just imagine how it feels to play the game with them. That's why a lot of times when we don't go into court properly, we don't get what we would call a favorable outcome, or the outcome that we're looking for, because we went in emotionally instead of strategically and tactfully. Okay, so what we just witnessed there was him saying, hey, look, you had this on your record that you were going to admit this as part of your evidence or discovery or exhibit, but then you're not utilizing it. Are you sure? And he goes, yeah, we're abandoning that. And he said, well, the justice said, well, wait a minute, you're bringing up these other cases, which this that you're abandoning actually supports. See, because they want to make the right decision for the infinity of it, not just you personally. I mean, of course, I'm not saying there's not corruption out there. I'm not just saying there's not going to be some biased situations. Don't get it twisted. We're talking infinity here. But what I'm showcasing to you is this was a great example of what I stated earlier, where they have to go by the law. Whether you're bringing in an international law into a Kansas court, and you're bringing in French law, or you're in Japan bringing in French law into Japan, the way the court systems are set up is they have to go by the law. So now what happens is he's encouraging them to, hey, are you sure you want to abandon this? Because he needs that, or I ain't gonna say he needs, but that admission or that exhibit to the court will actually help them make a solid decision. But we kind of need your permission to do so, right? So we don't seem like we're being biased or showing any favors. So, but hey, look, this that you're throwing out, it supports what you're saying. You sure you want to get rid of it? And that's when he's like, hey, look, you know what? Maybe I'll reinstate it, because now he's seeing, where he's at with it. Let's take a look at that. Maybe I'll replay it for you here in a second. Hold on, let me back it up a little bit here for you. All right, let's go from here. Hold on. One more. All right.
To that.
We believe that the delegation by Idaho under the Idaho Act to the target management of the right.
Oh, so wait. So I said all that to say, look, they'll help you in your first, get familiar. I'm not saying they're going to send you to law school in the middle of the trial or whatever, but they'll help you where they see you are making direction, especially if you know how to ask for, did they notice anything that would leverage the situation that you may have brought up, mentioned, what, I don't know, ask a question. I never had to do that, go in prepared, but I'm sure if you ask them, if you ask, because remember those who ask are asked king. So if you're asking or you're in control of the conversation, find a way to ask them, what do they see that that would have helped this dispute or in their trial history and stuff. Let them start talking to you to give you ammunition to help support you, because or to show you what you're standing against, because that's really what you're doing. It's not personal. It's the authority. The authority is the book or the quote that settles the question. All right, here we go.
Right to determine whether or not the Idaho Act would come into play constituted an unlawful delegation to a vitally interested private party in violation of the Civil Rights Act as expressed in 1983.
What civil rights?
We believe that there is a discrimination involved if an outside party is subject to state regulation only at the behest of another private party.
You still rely on 1983?
We have not brought that.
Does that mean you've abandoned it?
We've abandoned it.
You haven't brought it forward in the brief, but it's in your complaint. It's a jurisdictional question.
Yes.
And aren't you claiming that you have a right under the federal securities law that's being violated?
Yes, but not only under 1983.
Well, I understand, but that refers to the federal constitutional law. And you certainly are claiming that one of your constitutional rights is being violated under the Commerce Clause.
Yes.
Well, and you're suing a state official.
Yes.
Right. And they're also claiming a violation of the federal laws. 1983 speaks of constitutional laws of the United States.
Yes, sir.
You sure you're abandoning
it? I'll reinstate.
That's why they all laugh.
Mr. Easterbrook.
Mr. Chief Justice, and may it please the Court, the interest of the Securities and Exchange Commission in this case is in determining the validity of the application of state takeover laws rather than in identifying the proper forum for this suit. I will therefore devote my time to the Commerce and Supremacy Clause arguments.
If our interest is in identifying the proper forum for the suit, I suppose your argument is largely wasted then.
Mr. Justice Rehnquist, my argument would be entirely wasted if you find that there's no jurisdiction over this case. But in the event that 5 justices conclude that there is jurisdiction, I think the Commission would like to be heard on the merits. I'll address the Commerce Clause first, and then I'll take up the Supremacy Clause arguments. The point of the Commerce Clause is, we think, the creation of a common market. It forbids states from balkanizing the stream of commerce. More than that, it forbids states from reaching outside their borders to affect the flow of commerce elsewhere. Idaho's law affects an interstate market in securities. Its law applies to securities that are being traded on the New York Stock Exchange. Its law applies to an offer by somebody residing in Texas to buy shares from somebody else residing in Texas. And the application of this law doesn't simply, as in most Commerce Clause cases that come to this court, affect local commerce, but produce ripples elsewhere that are felt in other states. This is a case in which the very purpose of the state rule is to reach outside the borders of Idaho and tell people in Texas and New York and Florida whether and when they can buy securities from one another. It's as if the state passed a blue sky law and said, ordinarily you can decide not to deal in our state if you decide not to file our state registration statement. But we conclude that in order to protect the residents of Idaho from being eliminated or excluded from valuable opportunities to buy stock, no one can offer stock for sale in Texas unless he files a registration statement and sells it in Idaho as well. Otherwise, our residents are left out. Idaho indeed extols the extraterritorial reach of its laws as being justified by just such a purpose. That kind of justification has been rejected by this court, we think. It may be that the best example of that is Baldwin against GIF Seelig, one of the incredible series of New York milk cases that detained this court for some 20 years. New York tried to increase the selling price of milk in New York by requiring New York wholesalers of milk to treat the wholesale price of milk, even if bought out of state, the same as the New York controlled price of milk. As the court analyzed the case, New York was trying to tell buyers and sellers in Vermont what price they should charge for milk if the milk ended up in New York. And the fact that the milk ended up in New York produced a very substantial contact with the state of New York, the substantiality of which was not disputed by anyone. The milk had contacts with New York, just as Sunshine has substantial contacts with Idaho. But the court rejected any notion that New York could attempt to influence the course of commerce in Vermont, no matter how much the course of commerce in Vermont might ultimately have an effect on what happened in New York. That's exactly what Idaho is trying to do here. It's trying to influence the course of conduct in Texas and New York on the ground that that conduct ultimately has repercussions in Idaho. And the statute fails for the same reason, we think. But even if this statute were treated as one that applied wholly to a state's domestic commerce and merely produced its ripples elsewhere, it would be invalid because the ripples are great and the justifications for the act small. Idaho argues, for example, that it has the goal of protecting Idaho shareholders. One of the anomalies of the statute, though, is that it's not triggered by the presence of any shareholder in Idaho. It would apply if there were no shareholder in Idaho. On the other hand, the statute does not apply if the takeover offer is consented to by the management of the company, even if the management of the company is found in Washington state. And so in those cases, Idaho shareholders receive no protection. What's more is that what Idaho tries to do in a case like this is protect the 2% of the shareholders who live in Idaho, only by requiring the 98% of the shareholders who live in New York and Texas and Florida to forgo what they may find to be a valuable opportunity, is that its statute will protect civic-minded businesses or local commerce, health and safety, and the like. That amounts to, we think, discrimination against interstate commerce for its own purpose. It's an exaltation of the values of local isolationism from the stream of commerce.
Kind of
That's the kind of justification that was rejected in Philadelphia against New Jersey last term. The point of this argument has been that Idaho has had substantial extraterritorial intent, effect, and scope of its statute. It's those kinds of things that ought to be regulated by Congress if they're regulated at all. And in fact, Congress has regulated them. And that brings me to the point under the Supremacy Clause. In order to evaluate the argument which we make here, that the state law is preempted by the Williams Act, it's necessary first, we think, to understand why people make tender offers. Tender offer is a public offer to buy shares at more than they will fetch in the market. A person ordinarily makes such an offer only if he's persuaded that the shares will be worth more in his hands than they are worth held and distributed to the public at large. That may be because incumbent management is inefficient and mismanaging the company. In that event, the value of the shares will increase if new management is substituted by the offeror. It may be that tax considerations would make the shares more valuable in some hands than others if, for example, the target has operating loss carryovers. Whatever the reason, and there may be many, the offeror is relying on an increment in value. The problem is that it's very costly for firms to go out and identify such cases where there may be an increment in value, and they don't accept those costs unless there's some prospect of return. The prospect of return has to be discounted by the risk that the offer will be a failure. The greater the risk, the more return there has to be to make the offer worthwhile. But in order to realize the gain that he's identified, the offeror has to make the public offer and pay more than the shares bring in the market. Not too much more, though, and this is the difficulty from the offeror's point of view, because if he offers the entire increment of profit to the current shareholders, the highest possible price, there's nothing left for him, no incentive to do the searching, no incentive to make the offer. And without an offer, of course, shareholders will get nothing at all. So the closer any rule tries to drive the price to the maximum price, to what it's worth to the offeror, the less likely the offer is to occur in the first place, the more likely the shareholder is to end up with nothing. Time is of the essence in the tender offer process, and so is the opportunity to have a fair fight between the offeror and the incumbent management. It's most likely that the incumbent management feels its own personal prerequisites and position at stake.
Mr. Easterbrook, if tender offers are always so beneficial to stockholders as you suggest, why did Congress enact the Williams Act?
Mr. Justice Powell, there is substantial legislative history to indicate that Congress thought that tender offers were quite beneficial if conducted under a set of rules that allowed the shareholders to make an informed judgment.
They've often been beneficial, but they've often been quite adverse.
That's right. The difficulty lies in determining how that judgment is going to be made. One can construct a set of rules. There's going to be an offer. There's going to be a response by the target management. One can construct a set of rules under which someone, usually the shareholders, has to make up his mind whether the offer is beneficial or not, whether there is that increment of value. And the Williams Act was an attempt to set up that set of rules under which shareholders could make that determination. The pro rata provisions, the 7-day withdrawal provisions, the disclosure provisions were intended to allow shareholders to make that judgment. But it was a judgment that was to be made in the context of information from both offeror and the target management, the ultimate decision to be made by the shareholders. The difficulty in regulating in that way is to set up a system of regulation so that the shareholder can make that choice without at the same time so setting up regulatory rules that the number of beneficial tender offers is reduced and there are fewer opportunities for shareholders to make their judgments. Congress's assessment was that the best combination of protection for shareholders and insurance that tender offers would not be eliminated altogether was a set of disclosure rules coupled with prompt start of the offer. And Congress explicitly considered and just as explicitly rejected a variety of pre-offer notification rules or a variety of rules of the sort that would require the Securities and Exchange Commission to pass on the adequacy of disclosure before the tender offer could begin. But given the necessity of making the kind of balance, actually a rather fine-tuned one that Congress had in mind in the Williams Act, it must follow, we think, that a state cannot use the very devices that Congress rejected as detrimental to the interests of investors, because then the state defeats precisely what it was that Congress had in mind to achieve. Idaho simply is not free to strike a different balance on how best to achieve that. Congress recognized, however, that what it said in the Williams Act was not the last word, and it gave the Securities and Exchange Commission a substantial rulemaking power. In fact, almost every one of the provisions of the Williams Act is coupled with a grant of rulemaking power to the Commission to alter it, to change it in some way. In entrusting that rulemaking task, the fine-tuning task, to the Securities and Exchange Commission, Congress set up a system of regulation that is very closely related in concept to the system this Court considered last year in Ray against Arco, the Washington supertanker case. In Ray, the Secretary of Transportation had decided not to set up a rule under which supertankers were forbidden to enter Puget Sound, and had decided not to use his rulemaking powers, although he surely had them, to set up a rule requiring double bottoms, twin screws, and the like. Washington then required those things and gave as a rationale the argument that it was simply increasing protection of the environment, the very thing Congress had in mind in passing its statute. And it wanted to view the congressional statute and the Secretary's regulations as minimum guarantees of environmental safety, with the state adding additional guarantees of environmental safety. This court rejected that argument. The reason it rejected it is because the Secretary of the Treasury had the same power to assess and weigh the benefits of safety against the convenience of commerce. And it said that the state could not add where the Secretary had said there should not be additional protections. And that's really the same setup as works under the Williams Act. The Commission is free to provide additional period to increase the length during which a tender offer may be open. It's free to promulgate a great number of other regulations that will have the effect of assessing the benefit to investor against whatever detriment to commerce may be caused. And it's because the Commission has that authority and because it has decided to exercise it in a way that does not provide the kinds of things that Idaho has provided, the Idaho statute is preempted, we submit. And therefore, under both the Supremacy Clause and the Commerce Clause, if the Court reaches the merits here, we submit that it should affirm the judgment of the Court of Appeals.
Mr. Eastbrook, do you agree with Mr. Irwin that if the Idaho statute had been limited to intrastate activities that it would have been valid?
The Commission's position is that even if it were limited to intrastate activities, it would be preempted by the Williams Act.
Has the Commission taken that position previously to this case?
I'm sorry, Mr. Justice, I don't know whether it took it before this case, but that is the Commission's position.
So the Commission's position is that all 36 state laws are invalid?
It is, Your Honor. That should be distinguished, though, I think, from the Commission's position under the Commerce Clause. The position under the Commerce Clause allows states substantial authority to regulate within the state for the same reason that in Hall against Geiger-Jones, the Commerce Clause permitted blue sky laws. On top of that, I think it's important to point out that the Commission does not argue that all state laws touching on takeovers are preempted. For example, a state law requiring any statements by offeror or management to be fair, adequate, and so on, similar to or tracking the federal law, could be enforced.
Any state law that makes additions to the requirements of the Williams Act would be invalid under that analysis?
No, I think the Commission is not of that view. It's any state law that makes additions of the sort that disrupt the balance of investor protection established in the Williams Act.
Even if limited only to stockholders within the state?
Yes, Your Honor. But I think it's important to point out, and I think it should be clear, that in the Commission's view there are a number of possible state statutes that would not disrupt the balance. Take, for example, a state statute that says any corporation incorporated in this state shall respond to tender offers only by a 2/3 vote of the Board of Directors, or any of the other things regulating the affairs between the corporation and its shareholders, would in most cases not be preempted by the Williams Act. The test is not simply does it touch tender offers. We're not making a field preemption argument. The test is whether it upsets or undermines the careful balancing that Congress has done and its assessment of where the interests of investors lie.
Would it make a difference if the state statute is limited to corporations incorporated under the laws of that state?
I think that would substantially reduce the opportunities for disrupting the balance that's been created by Congress. The difficulties in allowing a state to regulate even those offers that are made to its own citizens might arise if, for example, New York, where 35% of shareholders lie, has a statute saying you must do A. California, where there are another 30%, has a statute saying you can't do A, and each tries to tug the balance in a slightly different way. The opportunities for that, when more than one state can enter the picture on one tender offer, are really quite substantial, and it's for that reason that the Commission says that even as applied to shareholders within the state, the acts are in many cases preempted by the Williams Act.
Mr. Heiser, you have a few minutes left.
As a preliminary matter, Mr. Chief Justice, I would like to point out to the Court that the typewritten brief of the Securities Exchange Commission was only received by us on the 5th of April with corrections on the 9th of April. The printed brief, we were able to pick up a copy here yesterday. Have not received it yet. I would like to request that I have an opportunity to respond to that brief in a written form, if the Court would grant me that opportunity.
You may respond if you wish in the usual way.
Thank you, Your Honor. One of the frustrations that the Idaho appellants have in this case is that the Securities Exchange Commission, where it had a real opportunity to provide enlightenment for this court as to what Section 27 really involves and what Section 28 conflict may mean in their terms, ignored those issues. And like the courts below, because of the fascination of the merits, which certainly are fascinating, leapt right into the constitutional questions. And unfortunately, in doing that, they use some of the cliches and terms that have been used all along with regard to these state laws, which have had a salutary effect. Talk about the term delay. State laws have prolonged the period during which tender offers are open. The net result of that has been, in the period between 1974 and 1976, a $1.2 billion premium to the shareholders as a result of that extended period of time. But the point that we really have focused here is that we have a Texas corporation that wanted to take over a controlling interest in a corporation that was subject to jurisdiction under the Idaho corporate takeover law, and the Texas corporation, a corporation with operations in Texas, knew and recognized that Idaho law was going to have jurisdiction. They came to Idaho to submit themselves to the jurisdiction of that Idaho law, and then when they didn't get the immediate approval that they wanted, their reaction to test the constitutionality of the Idaho law was down in Texas. And that is unfortunately what creates the problem in this case. We shouldn't be having to be concerned about defending the action in Texas because it shouldn't have been brought in Texas. It should have been brought in Idaho. And if a corporation like Great Western United wants to do, as it does, business in many states, then it should be prepared to conform to the problems that it may be presented with by the laws of those states. And if it has constitutional challenges to the laws of those states, it is perfectly free to go into the federal courts in those states or the state courts in those states and raise those constitutional challenges.
By the same token, of course, the respondent company says that what Idaho did had a direct impact upon what the respondent wanted to do in the state of Texas.
Well, Mr. Justice Stewart, what the respondent wanted to do was not only in the state of Texas.
And the other 49 states also.
Exactly. And under the rationale advanced by the courts below, then because of the effect in all of the other 49 states, they more than likely could have brought suit in any of the other 49 states, and we could have been defending an action in Vermont or Hawaii or Alaska or Florida, as well as Texas, because Great Western United wanted to secure shares of stock from shareholders in those states. So the problem becomes the forum shopping problem, and that really is not what we feel the federal law was designed for, and it certainly isn't what we feel that the Texas long-arm statute and the accompanying federal venue statute were designed for. That's the whole point. The U-Anchor case that the Texas Supreme Court recently decided that construed the Texas long-arm statute, it is absolutely true that they said that the Texas long-arm statute goes to the full limits of due process. But what was the context of the case? A contract, one of the specifically defined terms that constitutes doing business under the Texas long-arm statute. The threshold first level of inquiry under the Texas long-arm statute was satisfied, so they didn't have to waste time on deciding whether it was an act of doing business in Texas because it fell within the actual definition. But what the court did do in U-Anchor was finding that, yes, the facts technically satisfy our jurisdictional prerequisite in the Texas long-arm statute as a doing business context. I see I'm out of time. Thank you, Your Honor.
Thank you, gentlemen. The case is submitted.
So there, is this your first time with me here where we sat through a court case, arguments? That's what it sounds like. on that level of play, and it's really fascinating. I mean, this is what we have to do, people. This is what we got to do. We got to put the fucking work in. Okay, you're giving these people called attorneys hundreds or thousands, or some cases hundreds of thousands of dollars, simply because you don't know any better. All right, and then if you have what you call men in your life, or you're dealing with kings, or you got gods, little god, protect what, how, you know what I mean? That's the biggest issue with society, is everybody's wanting to say, they're protecting this, they're holding down that. If you can't talk, how can you protect your household, your kingdom, your universe? Okay, so Pasha, it's 2 hours and 40 minutes you're on this live, and okay, you know what, you didn't say that the last Super Bowl you watched. All you had at the end of the Super Bowl was some blips, some beers, whatever, some wings, and you're gonna be able to tell a couple stats while you're sitting in jail, or while they're giving your wife a ticket for something. You know what I mean? What value is your time producing? So that's why you are here today. If you made it this far, I appreciate you, because you're going to be the mindset that I'm looking to build with in the future, regardless if it's music, business, or whatever. I've gone without business. I've passed on deals purposely because they're not going the same direction that we need to go. Challenging, all right? But that's what we got to do, because as soon as they say, hey, ban you for knowing this stuff, guess what? You're going to get blackballed. You're going to become victim of the cancel culture. I'm not, that's just what it is, okay? So this is Venue. Go back and watch the beginning where we broke down Venue. I gave you the information out of the Civil Resource Manual. I gave you the detail we reviewed out of the Black's Law Dictionary, official 3rd edition, 1933. We looked at Section 28 USC 1391, and I even gave it to you guys in an informal, like, this is what it would be if it was you in a relationship terminology, so that it can help make sense for either the younger audience or people that are just unfamiliar. Okay. And then we watched the case where we got to see the live play-by-play, so to speak, on ESPN, of how they actually executed the same thing we just went over in a real court case. So if you review that a few times, do some additional studies, there really shouldn't be any reason why you couldn't go into a formal venue and contest venue by definition. And this is why I say we're taking a small step, because this is venue. All right. Then go back and look at standing to sue. Then go back and look like at the last video I did. I mean, you may have to go to the YouTube channel YNet7, right? Y space NET space 7 to get the other stuff. But go back and look at where we did exhaustion of administrative remedies. I mean, if you got a job, if you got anything that you're dealing with, different tier levels, I mean, you're going to want to know that, so that you know what your rights are and how to effectively navigate, when you've been subject of a tort. So go subscribe to the YNet7 channel. I'm gonna keep giving this to you, and but this is what we need to do. Okay, the destination is not just for me to be on here talking about this, but for everybody, not just for one person to be up here telling you what they believe revenue is and how it works, but for everybody to know. We need to get rid of the clicks. You know what I mean? Because they're fucking shit up. Because then they go and say, oh no, you can't join us unless you do this or that or that. I mean, you know, it's kind of like, that's the problem. Everybody wants to have some sort of control over shit when authority is the book or the quote that settles the question. Give everybody access to the book or quote that settles the question. Get rid of currency. Give everybody access to life, liberty, and the pursuit of happiness. Stop trying to be a gatekeeper because you saw somebody else gatekeeping and you were upset. You hated that, and now your brain from 7 through 13 is now acting out, saying, "Hey, I'm going to take my ball now that I have a ball, and I'm going to go home and I'll pick who can play with me because that's what they know." I mean, yes, you can do that, but look at the damage it's causing. Give it to everybody. You're not the authority. The authority is the book or the quote that settles the question. Stop gatekeeping. That's dead. I don't care if it's music. I don't care if it's codes and statutes information. I don't care. Like life, liberty, and the pursuit of happiness. If you're not helping to feed that, then you hating on the nation. And if you hating on a nation, then you might as well be part of China. So now if you are a part of China in America, well, you get the picture. All right, we gotta figure out this venue situation. Pasha Pyro, YN7, Pasha Pyro Music. Join the frequency.